as a common man or as a lawyer or a professional, we keep on hearing that you should bring a nominee, whether you are nominated in this particular bank account, etc., or you have to bring a legal hair certificate, etc. Are the both words interchangeable, or are the processes for the same also the same? These are certain nuances which one wants to always understand. And who else could make us understand better than Mr. Srinivasan Raghavan, who has come on our platform on upteen number of times, and every time he comes, his session is always well received. On different perspectives of law, different spectrums of law, we have been taking sessions. They have always been well received. And therefore, we thought, though the topic looks simple, but when we were talking to Mr. Raghavan outside the platform, we found there are certain aspects which one requires to understand. And in fact, when we thought it would be by one part, today Mr. Raghavan called up early in the morning. He said, no, the journey seems to have to be taken in the two parts. We said, be that as it may. As long as the participants are going to be enriched, we can make it even two parts. Without taking much time, I'll ask Mr. Raghavan to take things forward.
Yes, sir. Thank you very much, Vikas, for the opportunity once again. So happy to be a partner with you in this knowledge sharing platform. So today's topic is somewhat relevant in the sense that we don't normally require a legal advice whenever there is a claim on the part of the parties to investment. For example, whenever there is what is called a savings account, or whenever there is an equity share in the listed companies, and whenever there is an investment in mutual funds, and even whenever there is a kind of debentures or shares or any other movable assets in the name of a person, the person who invests in such institutions, financial institution, normally is called upon mandatorily to make a name and nominate somebody by what is called a nomination. So the person who invests the money in any of the forms or deposits the money in the fixed deposits or in the bank accounts, or who gets an equity share or he invests in mutual fund is mandatorily called upon to fill up a form called a form for fixing or naming a person called a nominee. The question is very important in the sense that once the person who invests the money is no more alive, and if he dies intestate without leaving any document or any will, then the problem starts. So what happens normally, there may be one person who is named as a nominee in the records of the financial institution or the company or the bank, as the case may be. So the person who is so nominated as the nominee is all set to take the payment out of the institution. Say example, I have invested a sum of rupees 25 lakhs in the form of fixed deposit receipts, or I have got some share certificate with the face value of 20 lakhs in some listed companies, or I have a debentures, or I have a mutual fund, or I have an LIC policy, any kind of investment in which I named somebody as a nominee. So the question is, after my death, if I die intestate without leaving any record as to how the property and investment should go after my death, the nominee may try to take the entire amount into himself, leaving the others in the lurch. This is a situation where the law is playing a pivotal role. But unfortunately, initially when I thought of handling this topic, I was sure of the legal provision or legal position. But when I went through a little bit of research in finding out what the law is about, I was in a quandary. I was rather surprised and shocked to know that different kinds of enactments had different kinds of directly opposite propositions. If I name some of the legislation which may be important for the viewers to understand why there is such a dichotomy in the issue of nominees versus legal heirs. Any person who has common sense, or any person who has come legal tinge, or any person who has got some experience in the family on account of death of their father or mother, may immediately say, no, it cannot be the case. Only the legal heir will have prevalence over the nominee. But friends, please find that that is not the case with the provision of law. So if I say these sections on provision of law and the enactment where the law is different, you will be surprised and you will be rather shocked also. For example, section 109A and 109B, capital A and capital B of the Companies Act, and section 64(1), subsection 1 of section 64 of the Estate Duty Act 1953 is no more relevant. Anyhow, there is a legislation. Section 39(7), subsection 7 of section 39 of the Insurance Act 1938, and section 45 is that A of the Banking Regulations Act 1949, Rule 2 of Banking Companies within brackets Nomination Rules close the brackets 1985, Bylaw number 9.11 of the Depositories Act 1996, the Securities and Exchange Board of India within brackets Mutual Fund close the brackets Regulations 1996, Regulation 29A, and Government Savings Certificates Act 1959, Section 6, 7, and 8, and Section 10, subclass 2, subsection 2 of Section 10 of the Employees Provident Funds and Miscellaneous Provisions Act 1952, Section 39, I repeat once again, of the Life Insurance Act 1938, and Section 58(2) of the Indian Succession Act are relevant. So, barring the last provision of law, namely Indian Succession Act 1925, with specific reference to Section 58(2), other provisions are having operation of their own nature, unmindful of what the succession laws are. Now, before going to the different provisions of law governing nomination under the various enactments, we have to understand that there are only two modes of succession known to the Indian personal law of succession. B, it's a Muslim, B, it's an Indian Christian, B, it's a Hindu. The law contemplates only two kinds of succession: testamentary succession and intestate succession. Intestate succession may make a different shape in the case of Hindus by going to co-pass marriage, and we are not on that. So what I want to make it very clear that the law of succession in India is a personal law. That means it depends the religion which he professes. We have a separate law for succession governing Hindus called Hindu Succession Act. We have a separate act for Christians called Indian Succession Act, governing Christians for non-testamentary succession. And we have Muslims law of Shariat regarding the Muslim law of succession. So Indian law of succession is based on the religion of the person, so it is called a personal law. So we have only one secular or uniform law for testamentary succession. Whenever there is a will, the law is only the Indian Succession Act. But of course, Indian Succession Act, that is only legislation that is secular in nature and applies to all the religion commonly, has got some exception for the will executed by Muslims or Muslims. Because Muslim law of will and hiba is totally different from what the common law is about. And you may be surprised that Hindus never had the habit, or Hindu law never permitted execution of will before the 1898 or something, where the first Hindu Disposition of Will Act was enacted by the British Parliament. So even writing a will was alien to Hindus before the act came into force. So now I told you very specifically that there are only two modes of succession in India. One is testamentary, another is intestate succession. Now, when we go for a third succession, the law does not permit any other mode of succession. A person who is an Indian is governed by either the personal law for the non-testamentary succession, and for testamentary succession, he is governed by the Indian Succession Act, subject to some exception for Muslims and other. So now the question is whether the provisions relating to appointment of nominees will be in a position to operate as a third branch of succession in Indian soil. That is the million-dollar question we are supposed to expound today. So I told you that the Estate Duty Act 1953, it has got a separate provision, section 64(1). I don't want to waste much of the time by verbatim reproducing the provisions of law. You may take note of the provisions and go through later when you find leisurely time available for you. So subsection 1 of section 64 of the Estate Duty Act has got a special provision for nominees. Section 109A and 109B of the Companies Act has got a separate special provision for nominees. Subsection 7 of section 39 of the Life Insurance Act has got a separate provision for nominees. Section 45(ZA) of the Banking Regulation Act has got a special rule of nomination. Banking companies within brackets nomination rules 1985 is a special rule applicable for such nomination, and rule 2 speaks of the same. And bylaw number 9.11 of the Depositories Act 1996 that comes under the Banking Regulation Act speaks, and Companies Act speaks of what kind of effect the nomination can take after the death of an investor. And Regulation 29A of the Securities and Exchange Board of India, within brackets Mutual Fund Regulations 1996, has got a separate rule for nomination and nominees. And the section 6, 7 and 8 of the Government Savings Certificate Act 1959, it has got a special rule of nominees. And the subsection 2 of section 10 of the Employees Provident Funds and Miscellaneous Provisions Act 1952 has got a special provision. And section 39, I told you, of Life Insurance Act, they all are special provisions relating to nominees only. Now, an interesting question may arise for consideration in the minds of viewers who know law well. The basic law of the land is this. We have got two kinds of laws, general laws and special laws. General law is a wider connotation. It speaks of the law as a general applicable as a whole for the citizens. Whereas special law is a specific law which is applicable for a special purpose. It's called local law also. So, general law and special law, when they clash with each other, normally special law or local law will yield. That is the tools of interpretation of statutes we have learned from the college days. Now the question is whether the provisions above said, I told about the provisions in the Companies Act, Estate Duty Act, Life Insurance Act, Banking Regulations Act, Banking Companies Nomination Rules, Depositories Act, SEBI Regulations, Government Savings Certificates Act, Employees Provident Funds Miscellaneous Provisions Act are all special laws, means general law will have to leave place for them. If that be the case, what is wrong for the special laws to have a special provision, thereby making way for the legal heirs? So I'll come to the conflict straight without wasting much of the time. The conflict is we have a Hindu Succession Act wherein Section 6 and 8 are applicable for Hindu succession, applicable to Hindu males. We got Section 15 applicable for Hindu females. After the advent of the amendment in 2005, Section 6 will apply to the newly made co-partners women Hindus also. So we have got Section 6, 8 and 15 under the Hindu Succession Act governing succession for the Hindus. We have got Sharia Act for succession for Muslims. We have got Indian Succession Act applicable for Christians. Under all these succession laws, the law is very clear that legal heirs are entitled to the property of the deceased depending upon the intention of the deceased property holder. Had he left any will or any disposition or any disposition or alienation, that will govern the field. The dispute is twofold. Number one, he has left a will wherein he has given the properties, including the deposits, money, etc., to various persons on one hand, and he has executed a nomination in favor of anyone or any stranger who is not the beneficiary of the will. So now scenario number one is legal heirs on one hand versus nominee on the other hand, when there is an intestate succession. Scenario 2 is legal heir who is the beneficiary of the will, or the person who is the beneficiary of the will on one hand and the nominee on the other hand. What is the law of the land is the question. Let us go for an example. A Hindu male dies intestate. Assuming for a moment that his properties are self-acquired by him, it is not the property which is co-personally in nature. So when he dies intestate without leaving any will, Section 8 of the Hindu Succession Act operates. As you all know, Hindu Succession Act has got schedule wherein we have got a lot of legal heirs classified into Class 1 legal heir, Class 2 legal heir, Class 3 legal heir, and Class 4 legal heirs. So the entries in Class 1 legal heirs will take the properties together in equal share. When there are no entries in Class 1 legal heir, Class 2 legal heir will come. When there are no Class 2 legal heirs, Class 3 legal heirs will take. And when there are no Class 3 legal heirs, Class 4 come. If a Hindu dies without any one of the Class 1, Class 2, Class 3, Class 4 heirs, the property goes to government called estate. So the question is, on the death of a Hindu male who died intestate, the properties will be divided as per the provisions of the Hindu Succession Act. In case of male, it is Section 8. In case of females, it is Section 15. So now the question is that a Hindu male dies intestate, for example, leaving behind his wife, one son, and one daughter. So as per the law of the land, Section 8 of the Hindu Succession Act, the property is divided into 3 halves. 1/3 goes to wife, 1/3 goes to son, and 1/3 goes to the daughter. Assuming for a moment that in the government pensioner payment order, PPO, or any other documents relating to his terminal benefits, or any insurance policies, or any debenture or shares, or any other investment, the deceased male during his lifetime appointed only his son as a nominee. So what will happen on the death of the father? The son will straight go to the company in case of shares, or he'll go to the bank in case of deposits and savings banks account, and goes to any other financial company in case of mutual investment funds, and go to the office of provident fund for in case of any GPF account. What happens is that the institutions who are governed by a special or local laws, like the Companies Act or Estate Duty Act or Insurance Act or the Banking Regulations Act or the Insurance Act, are bound by their own laws. If the personal laws governing the company or the insurance corporation or the bank or the society are governed by their own law, and their own law speaks of nominee as the person to whom the property should go, what will the department do? They are answerable for the nomination because that was the intention of the deceased during his lifetime. So normally what the institution to whom a certificate is given of death certificate is given, they will call for the legal heir certificate, and they will try to call for NOC of the other legal heirs if anyone claim. But the rules are not so. In fact, the Banking Regulation Act is very clear, and it contemplates the deposits are vested with the nominee. So the question now arises is this: there is a nominee in the books of the institution where the deceased had left the investment, and there are sets of legal heirs who have got a right over the property by means of operation of the personal law of succession. So between the two, now there is a clash. In the said example, the son, who is the sole nominee, goes to the bank and asks for the money to be transferred to his account. Assuming for a moment that the wife and the daughter have come to know that the son wants to usurp the entire property, so they approach the bank and lodge a protest stating that, sorry sir, we are the class 1 legal heirs. Along with the son, he is not the only legal heir who is entitled to take the entire property. He is after all a nominee. Please say no to him and pay the amount as per the Hindu law. If that be the case, the bank is supposed to do what is the question to be seen. I had a doubt last week by my colleague who has come with a similar doubt. I was telling the law of the land in force, being a lawyer who has been practicing this field, this is the law. But after the friend has left the office, in my own inquisitive nature, I just probed into the provisions of law when I came to know all the provisions. The law of the special subject is different. So when I spoke to the bank manager, who is my friend, who told me, no, we have got a bank manual, which has got a specific provision. Only in the event of dispute being raised by any of the contestant or rival claimants, we direct the parties to go to the civil court. For example, in the said family, the wife and daughter goes to the bank and lodges a protest, stating that, I'm sorry, I am one of the legal heirs. Either the wife or the daughter or both, they may go to the bank and lodge a protest. When such a protest is made, what the manager is supposed to do? So I'm told that the manager will ask the parties to go to the civil court and obtain a certificate, what is called a succession certificate. Members, please find mind in your knowledge that succession certificate will not be issued when there is a will. A person died interstate, succession certificate is issued. So when there is no will and the parties fight among themselves, and one of the person being the nominee wants to take the entire property, the remaining parties fight, and the bank will ask the parties to go to the civil court, get a succession certificate, and thereafter the bank will decide and distribute the amount as per the order of the court. Okay, understandably right. Scenario number 2, when there is a will. In the will, the father has given the entire property or a portion of property either to the wife or to the daughter. Whereas the son, being the nominee, wants to take away the entire money. What the bank is supposed to do? The banking regulation says that the bank has to ask for once again a certification of the court for the will called the probate. The person who is the beneficiary of the will has to apply to the court under the testamentary jurisdiction and apply for a probate. There is a difference between probate and the test of administration in case of a will. When the will is executed by the testator, that is the maker of the will, if he has appointed anybody as an executor, the executor has to apply for a probate. If the maker of the will called the testator has not appointed anybody as an executor, then the beneficiaries called the legatees, they have to apply for a letter of administration. So I repeat once again, scenario number 1 is this. There is a family. The father had left a huge investment in a financial institution. He died intestate, leaving behind son, daughter, and a widow. He has named his son as the nominee. Whereas on the death, his wife, son, and daughter, they have got equal share in the properties of the deceased as per Section 8 of the Hindu Succession Act. Scenario number 1, the daughter and mother or daughter or mother may go to the bank and object to disbursement of the entire amount to the son. Number 2 scenario is the father died after leaving a will in which he has either left a share of the property to the wife and daughter, or he has left the entire property to wife or daughter, having nothing to the son. That be the case also, this daughter or mother or both can approach the bank and lodge a protest. So the law, the manual of banking regulations calls upon the bank manager to direct the parties so they go to the civil court. In the civil court, in case of any will is available, the bank has to direct the parties who propounds the will to obtain a certificate called probate from the court concerned. I repeat once again, when there is an executor appointed in the will by the testator means the person who executes the will, the executor has to apply for the certificate of probate. If the executor has not appointed anybody, if the testator has not appointed as anybody as an executor, so the legatees called beneficiaries after the death of the testator has to apply for a letters of administration. Scenario number 2, when there is no will, all the three fight together, the bank manager or whoever is in charge of the institution of finance has to direct the legal heirs to go to the court and apply for a certificate. The certificate is called a succession certificate. Once the parties to dispute produce a certificate, the bank is supposed to act upon the same. So banks are very clear on this subject. But there are some institutions like the insurance companies and companies, listed companies, and some financial institution coming under the SEBI. Their rules are in the nature of saying that the amount or property or the monies vest with the nominee. So it is now at this juncture, this becomes an important point. Between the nominee and legal heirs, who has got a right over the property? So as I said, there are special laws called Companies Act, Estate Duty Act, Insurance Act, Banking Regulations Act, Banking Companies, Depositories, SEBI related insurance investment companies, government savings certificates, EPF and GPF, and LIC policies. They have their own rules. In case of nominees in the said documents in favor of one individual, and there are other legal heirs fighting outside the institution, what is to be done is the question to be seen. So there are umpteen number of judgments. So my first session today is in the nature of confining to the party's knowledge. There is a wide misgiving in the minds of a lot of people, especially practicing lawyers, stating that the laws are unanimously in favor of preferring legal heirs as against the nominees. I say, I'm sorry to say, that is not the law of the land. The purpose of spending more time on part 1 of the subject is to make the advocates and participants and viewers to understand that the laws are not uniform. The laws are not consistent, and there is no consistency between the special laws themselves. Some of the local laws are in the nature of vesting the money in the name of the nominees. Some of the rules are flexible. Some of the rules direct the parties to go to civil court in case of any testamentary succession called a will. So now the question is, when the local laws have got special rules, when the general law of succession speaks of succession as per the succession laws only, what the institutions are supposed to do in the event of clash of interest? Claim by the nominee on one hand, and claim by the legal heirs who are not nominees on the other hand. If they clash, what is the duty of the institution, thereby avoiding any litigation, driving the parties to nuts? So I just want to conclude the first session of the day today by saying that we have got only 2 modes of succession in India. That is called testamentary succession and intestate succession. There is no other third mode of succession in India. By saying so, what I want you to infer is that there can be no different mode of succession than the testamentary or intestate succession under the personal law of succession. So no local or what is called a special laws can create a third mode of succession. So the first golden thread I want to emphasize is this: there can be no alternate to the two established mode of succession. There can be no third mode of succession called a succession that is outside testamentary and non-testamentary succession. Number one. Scenario number two is that there are local laws and special laws where there are specific provisions governing the nomination. And such local laws are in the nature of giving a right of vesting of the property in the name of the nominees. So the same scenario or same meaning or language or the same intention imputed to a will can be imputed to a nominee also. Whenever a will is put into test, the court used to say that the court has to give respect to the intention of the testator. What was the intention of the testator is reflected in the will. So the courts are bound to honor the intention of the testator. That is the purpose of the execution of the very will itself. So a nomination is also said to be a kind of declaration by the deceased that he expresses his intention that the amount should go to a nominee. Whether a nomination is in the nature of a disposition in the form of a will. In the absence of a will, whether a nomination can be considered to be a last wish of the nominee, so that other legal heirs can be ignored. So this is the interesting proposition of law we are going to consider. And next session, I'll come with specific judgments of at least 4 high courts and 2 of the Supreme Court judgments, by which we can discuss the law and come to a conclusion by discussing the case law on the hand. With this, I request because to permit me to close the topic of the day. Because the forum is yours now.
Yes. Mr. Raghavan, one question is, can post office ask for succession certificate even if there is no objection from the legal heirs?
Of course, departments, they want to rule out any problem because a person claims to be a wife, may not be an actual wife, he may be a second wife, and there might be a case where there are doubts as to the validity of the marriage. So all departments, they have as a abundant caution call for succession certificate. We cannot say that you are not supposed to ask for. If they ask, you have to move the court for an appropriate order. They have got every right to question the legality of the legal certificate you submit.
But in a lot of cases in the post office sector, normally if there is a nomination, they allow the certificate to be transferred in the name of the nominee, or they issue the same amount in favor.
What is going on all over the country, but the courts have frowned upon the same with heavy words. But unfortunately, how the post office knows that there is a rival claim?
That's what I'm saying. They say that in case there is a rival claim or somebody writes a letter, then in that eventuality, then they can insist upon, or then they can say that you can take the document, but you will have to ensure and certify that it will be divided.
Exactly. But when there is no rival claim, for example, other legal heirs are not aware of the move of some legal heirs being female, they may not be even aware of a deposit by the father in the bank, and only the son may have an access or knowledge of it. That is normal case. Normally, husbands don't disclose the assets to the wife during their lifetime.
Even to the children.
There are chances, Mr. Vikas.
Yeah. Today we are having a lot of questions. Before we are discussing, the questions are just pouring in. Just hold on. Please explain the difference between a legal heir certificate and a succession certificate.
Legal certificate is issued only by the revenue department. It has got no legal sanction. Please bear in your mind that there is no law in India governing issuance of legal heirship certificate. These certificates are issued only under the governmental orders, whereas succession certificate is issued by the courts under the authority of the Indian Succession Act when there is no will at all. Legal hardship certificate is only a executive order which has got no legal backing. They are governed by GOs, not by any act of the parliament or the assembly.
Yeah, this is by Grish. Is there any time limit for rival claims to be made?
No, actually, Madras High Court very strangely has created a point of limitation for probate and certificate, but in the appeal it has been set aside. For the purpose of creating a claim, there is no limitation, and it is a recurring cause of action. At any time, a claim can be made, and there is no bar of limitation.
Muthu Kumaran, can a court issue succession certificate in respect of a immovable property?
Respect of immovable property. Yeah, they can do it, provided there is a dispute as to the relationship, and then there is no will. If there is a will, they cannot issue.
This is by Anshu Agarwal. If we forget to add some shares in the succession certificate, can we pay the stamp duty to add them subsequently?
You can go for any number of certificate by paying stamp duty. Supplemental certificate can be issued.
So, but in the supplemental, again, that same rigors would be followed?
Same
publication, objections, etc.
Yeah, exactly.
Okay. These were the questions. And thank you, Mr. Raghavan, for sharing your knowledge. And that too, one question is there. Last question. What is the law regarding share certificates?
Same only. In fact, I told you, section 109A and 109B of company law. If you come to the session next week, I will discuss it. The case laws are being discussed. The same law applies to companies also, share certificate also.
Yeah. If there is a contradiction between a bank nomination and will, which one will be taken?
Will be taken, but provided you prove the will in the manner known to law. Bank will not take the proof of risk of taking the job of proving the will by themselves. You'll have to go to the court to get a probate.
So, thank you, Mr. Raghavan, for sharing your insights. And thank you to all those participants who have been watching us live as well as subsequently. Everyone stay safe, stay blessed. Namaskar.